Hey there, it's Mike Goldstein here with the Best Known Attorney podcast. And today we are so lucky to have with us one of the premier bankruptcy and debt relief attorneys in all of Maryland and Washington, D.C. We're going to be talking live today with attorney Jill Phillips from the Phillips Law Offices. And we're going to do that just after this.
So then you put a commercial
Hey,
there.
how are you?
Good. How are you?
Very good. Well, I'm so happy to have you on the podcast today.
I'm glad to be here.
Yeah. Hey, so for all of our listeners out there who don't really know who you are, and shame on you, by the way, if you don't, Attorney Phillips is one of the foremost experts in bankruptcy law in the entire country, certainly very well known in Maryland, D.C., and even up into New England. But other than my, less than modest probably introduction here, tell us a little bit about who the heck you are and what it is that you do.
All right. Well, you may not want to know me and say that you know. Well, you may know me, but you may not want to tell people you know me. But actually, you should, because my name is Attorney Jill Phillips. I am a bankruptcy attorney. I've been practicing bankruptcy for over 20 years. I got my start in Greenbelt in PG County, Maryland, and still there, still doing bankruptcies there. I do chapters 7 to 11s and also some other consumer debt issues, and we advocate for, if you get in problems with your car or your house outside of bankruptcy also. So, we also do some cases up in Massachusetts. We do some adversaries. But in the span of 20 years, we've done pretty much everything you can do within Title 11, which is the code for, which is where the code is held for the bankruptcy court.
Oh, thanks. That's actually very helpful. So I think everybody now understands. We're dealing with a bankruptcy practitioner here. We're not dealing with a paper pusher. So this is somebody who actually goes into court and is able to help people. So one of the things that we do on this podcast is we're talking to other law firms, other attorneys, legal marketers, and talking about different ways that you can expand your business, either by getting your internet marketing right or by making some of your processes and your procedures more efficient. But one of the things that I know that you have really done really well with over the years is being able to work with other attorneys and helping them find you the right client for you to work with, where oftentimes they'll have somebody who is in a debt situation. They'll have somebody who frankly falls outside of their practice area, and you guys will be able to work together. So with all that said, when you're looking as a bankruptcy practitioner at something that you think you can help, what makes an ideal bankruptcy client?
Well, a client, it comes in a couple folds, but the main fold, I think, there's actually three if you look at it, between the Chapter 7, Chapter 13, Chapter 11. Generally, the Chapter 7 case would just be someone who got in over their head, made some mistakes with credit cards, maybe past due rent, maybe you're facing, a repossessed car when they were younger. And it's really the threshold is their income, which determines a Chapter 7. They don't have a lot. They're just trying to get through all those mistakes that they've made or had to run up because they got sick. And their income is at a certain level below the means test. But they do have income. So we're able to help that person clean up their credit and move forward. And that's a great client because it's a restart. And it's fantastic for that client because they're able to stop all the stuff that's coming after them. Garnishments on their wages, lawsuits, just all the letters and the phone calls and the fear of all those mistakes coming back to them. It's a great way for them to clean their credit up and then move forward and then buy the houses and get everything that they want in the future. Sometimes that happens because they got sick. Sometimes it happens because they are in a divorce situation. Now, a Chapter 13 case is really a little bit more complicated, but that generally happens when people are a little bit older. They have houses, they have tax problems, they have kids. And an ideal situation with a Chapter 13 would be someone who just also had a hiccup, had a problem, maybe lost work for a couple months because they were sick, just got behind in a few months on their mortgage, maybe behind their house or have a tax liability. We're really able to reorganize them and keep what they want, what the big assets are, like the house, the car, and deal with the taxes. And that's usually someone who has a pretty decent income and is able to manage those. Now, Chapter 11s, of course, are corporations, and we don't do a lot of small business corporations because often small businesses are wound up and restarted a different way. But Chapter 11s are a good way for some corporations, some small businesses, the same way as the 13 got in over their head on a few things, got behind, maybe had a delay in shipping, or part of the some sort of supply couldn't get to them, so they couldn't make their product. So that's a great way to reorganize also business and continue moving forward with what they have, their assets in their business. So an ideal situation with all of them is really when someone comes to me is understanding they have an issue and we're willing to listen and can resolve it through the bankruptcy, because there's always a couple of stages. It's like kind of like death, where C.S. Lewis talk about death, and there's a denial, there's fear, there's anger, and then there's acceptance, because you go through those stages as a person with debt as well as death, because we want to kick ourselves when we make a mistake. We want to be angry at the ex-boyfriend who didn't pay the car loan, right? These are things that we go through, but then once we get through all that and we can focus on what's at hand, and that's what they have to take care of their debt, and that's very helpful when a client comes to me and really is looking for some help and really wants the help.
Thank you. That's actually very, very, very helpful. So basically, at the end of the day, you said a lot of stuff. What you're really saying is, when people come to you, little things are stopping, big things are popping.
Yes, that's right. Very good. Yeah.
All right.
Or the heat is on sometimes too, which is when they're facing a foreclosure or a repossession or a garnishment. I get it, but that's where we're ready. When we're ready to go for it, that's usually sometimes it kicks in at that point too.
That's fine. So let me ask you this: when you're working with, or even before you start working with someone, I would presume a lot of times, you deal with people who have multiple things going on in their life. Generally, you don't, as you said, maybe you're going through a divorce, maybe you had a traumatic injury, and that's why you're facing debt. So oftentimes I'm thinking you're maybe not even the first attorney, even the first type of attorney that someone talks to. Oftentimes, maybe it's a divorce lawyer, maybe it's a personal injury lawyer. So when working with people like that, what are the things that you would tell a PI attorney or a divorce attorney that where you might be able to help their client so that they can help, so that the other attorney can help their client, and kind of take away that stress level that maybe is stopping the kind of the totality of resolution.
So we've worked with divorce attorneys and personal injury attorneys for years, and even accountants with regards to tax liability. Been very successful with that, because often a divorce involves a lot of things. And one of the issues that often comes up in divorce is debt between partners, debt between husbands and wives and spouses. And what happens is that's a contentious part of the divorce. Who should pay for a joint credit card? No, you paid it. You charged all that. No, you charged all that. And often there are kids involved in a case. So, which then becomes about child support and alimony, and money is really a cause of divorce. I'm not an expert, and I don't have any, statistics right now. But what I have seen in my experience is that oftentimes, the bankruptcy sometimes even saves a family if you're able to resolve the debt issue, because it takes the pressure off of the marriage. But if you're at the point where the marriage is insolvable, just can't resolve the issues, a great thing with a divorce attorney, which we have had, is that a divorce attorney will come to us and talk to us. If there is an amicable situation between two parties, but they have a lot of debt and they can't quite get it resolved because they have a lot of debt, but the parties come to us even before they finally get divorced. They're going to get divorced. We know this. We can do a joint Chapter 7 and often resolve all the debt issues so that they can move forward, both of them, and focus on what's important in the divorce proceeding, whether it's child support or alimony.
So that's interesting. Let me just ask you a question. Now, what happens in a situation, though, where a married couple is going through that divorce, or they've gone through the divorce? are they able to still, when they're in that divorce proceeding, are they able to still file bankruptcy, or do they have to get separate counsel? How does that all work?
So you can file bankruptcy anytime during the divorce proceeding, and that's one of it. All depends on how the other side is, in the
Yeah,
sense of are we still able to talk, or we're gonna hate each other, and even if you hate the other person, you're not talking to them, but you're joined on the debt,
yeah,
and you just don't want to deal with that, and you're done with it. You can file right in the middle of the proceedings. There's nothing stopping you, and oftentimes people will get through the divorce and realize, whoa, I still have to pay a half of this. I'm filing bankruptcy anyhow, I might as well just do it and get it over with. But oftentimes, a divorce attorney will be able to settle things out, like child support and alimony and houses and everything, and gives advice to the client. Look, just because you're responsible for half of the credit cards, which might be 90 grand, you still are half you're responsible, because that's sometimes the code requires that in Maryland, what you're responsible for. You can still take the settlement, still deal with it, but you can always look at bankruptcy if you can't afford that. And oftentimes that gets everybody free and clear of everything that they need. Or I mean, no offense to any men, but oftentimes the a woman who's not getting the child support that she needs through the process, and there's very much a problem there, and she's working, she'll just dump the debt sometimes, and oftentimes that does force the hand and makes the child support issue it gets attention and gets it forefront. So the tool of bankruptcy with a divorce can be very beneficial for not only if you have children and you're looking at your children, but also moving forward from the divorce, because oftentimes there's baggage. People are paying debts. I had a gentleman have a credit card from a wife 20 years ago, and she was still using it. No one cleaned it up, and
yeah.
all of a sudden she stopped using it because she got sick. And then next thing you know, not intentionally wanting to screw her ex-husband from 20 years,
Of
but
course
his
not.
name's on it. I would go, maybe depending on how that was. But it's a good method if that's the case, right? But at the same point,
Long-term plan.
yeah, long-term plan of torture. But no, I mean, let's be kind to one another. But the reality is that he was locked on it because for whatever reason. That's the other thing to really mention about divorce, and this is a really good learning lesson. You can have a great divorce attorney who has everything in writing, but doesn't enforce a new card being issued, or the ex-wife or the ex-husband doesn't issue a new card, just doesn't take that step. And their attorney probably didn't, they're not required to, they probably didn't say you must do this, there's no statute of limitations or anything on that. But that's kind of how the settlement's designed. If he takes the card, it's his card now. She takes the card, it's her card now. In this case, she took the card, but he was still on it. So 20 years later, he has to deal with that debt. And he ended up going into a Chapter 7 and resolving that because of that issue. But those things can sneak up on you. So that's another thing if you are in a bankruptcy or not in a divorce. A bankruptcy might be like, let me just check my credit score, check my report, make sure I'm not getting hurt. And it might be an idea to just really clear the slate, not only from your marriage, but also your
Sure.
credit at the same
Now,
time.
and to take that divorce, the divorce referral a little bit further, I imagine oftentimes there may be situations where somebody was ordered to pay alimony or to pay child support, and they just don't do it. Now, that's obviously something that's a little more of a priority in people's lives, and even in the bankruptcy court. So you can't discharge that, right? But I imagine there are times where someone comes back to their attorney and says, "So I just haven't been paying it. I lost my job, whatever it might be." Are there solutions through the bankruptcy court that you can resolve that with? Because I mean, you could be looking at jail time if you don't make child support payments.
That's true. That's right. That's why you have to pay them. But no, that's a really good point.
Yeah.
And under they amended the bankruptcy code in 2005, and one of the options in a Chapter 13 is to catch up, because 13s usually catch up on arrears on houses. If you're facing a foreclosure, you can stop a foreclosure and catch up on your past due payments on your house. You can catch up on your issues with taxes. You can catch up on your past due payments on cars, but you can also catch up on your past due payments on child support or alimony payments, and you put that through the plan. because it is conceivable that someone who's required has a hiccup, and the divorce courts, yeah, you can go in and say, oh, reduce, but if you're going to getting unemployment, right, and you're trying to pay
Well,
rent, you're trying to keep your
yeah.
kids, I mean, it becomes difficult. So it's a great method for someone who says, whew, I got back to work, I fell behind a lot of things.
Mhm.
It's a great option because now you can catch up rather than trying to go back to divorce court, raise the child support, right? And go back and forth. You have the option of paying that through the plan, catching up like you do to everything else and reorganizing. And it's a great way for for people who do receive the child support who didn't get it, and it's a great method for the person who's supposed to pay for it. So it's a balance, and it's a good. That's one great thing of that amendment that came out of that amendment.
Now, what happens in the situation where, though, let's say there's a contempt order because you didn't make your child support payments, and the sheriffs are coming for you. You're going to jail. Can you do anything with the bankruptcy at that point?
Yeah, I mean, you can file the bankruptcy. I mean, the stay is in place. If it's a child support order, you stay everything. It has to be stayed.
So that will actually, if the divorce judge orders this, and if you don't pay in 14 days, you're going to jail. You can file a bankruptcy on day 13, and you're not going to jail. Is that what you're saying?
That's correct. That's correct. You stayed. You have a plan now. You have a plan to
Mhm.
resolve it. Now, the key is you have to file and go through that plan and be serious about that plan, not just stop it, right? Because it's great to stop the contempt order, but for 30 or 60 days, and it will come through. But if you really are serious and say, look, I just, you shouldn't get to the contempt area. You know that. Anybody knows that. But you really should step up and say, this is my situation. And I think a judge would agree. But if you're not talking to your ex,
Yeah.
it can get very emotional, and people can't let go of things from 10 years ago, and it all comes up because you're not paying child support. No one's listening. You can file that chapter 13 as a method to resolve those issues, so you can take a breather, take a stop sign comes up, and then have a plan presented and get your child support resolved.
So these are like really good situations or scenarios to, when working with a divorce attorney, or maybe even a divorce attorney who's listening to this and understands maybe I should talk to a local bankruptcy attorney near me, and we can work together and reduce the stress level of everything in such a contentious situation. But let's look at kind of another avenue where I know you've gotten a lot of referral work from, and that's from people who maybe were injured. And they can't work because they were injured, and they may not be able to work for years. So they're working with a PI attorney, right? And you got in the PI world, of course, you have to wait until you know the full extent of the damages before you can even make that demand. So it could be years before you do something. All the while you're not working. What is your recommendation to these PI guys who are in this situation? I mean, is it a good idea to talk with your client about bankruptcy? Is it a good idea to refer to work with a bankruptcy attorney while working out this PI situation?
Yeah, it absolutely can be. And I think PI attorneys underuse, I think, bankruptcy as an option. And it depends, though. I have to say that it depends on the state that you're in, especially Maryland. Maryland, there's some really great exemptions that can help people. You don't have to wait to file a bankruptcy, um, you know, to get your settlement, meaning you have to get your settlement and then file the bankruptcy. You can, like, if someone's injured, really injured out of work, and then they lose their job, because let's face it, employers are not so kind to people who don't come in, or 3 or 4 months, because they just can't wait. They feel bad for you, but
You get 90 days under the federal law. That's it.
yeah, it can't come in, right, and you're out. So if that should happen and you have debt that you have to, especially credit card debt, small debt, and there's a lot of pressure, that puts a lot of pressure on a personal injury attorney to settle the case. And the
Good.
problem with that is that sometimes you're not done treating with your
Yeah.
injuries. You might be severely injured. You might have to get a knee replacement. That will take you 8 months or so. Um, and you don't know how the knee replacement is going to take effect. Like it might be successful.
Mhm.
You might have to go for another surgery. So a personal injury attorney is going to tell their client, look, we want you to wait until we can actually get all the numbers on the table. But that might be too late. That might be too much pressure, because here's
Well,
a person injured, right? And they still have debt. they have to deal with.
So, I mean, it's too much pressure, I think, on the financial side. Obviously, the personal injury attorney doesn't want to file the case too early because they don't want to leave money on the table. But at the same time, I think there are ways. Now, one of the things I know that comes up, though, is when you do file the bankruptcy case before you file the PI case, or at least resolve it, who gets to, I mean, what happens when a settlement offer does come in? I think, sometimes we have very difficult clients that we're working with, and they want to make emotional decisions. Do they still get to do that when they're in the bankruptcy, or is there anybody else who steps in?
So if you file the case, and let's say you go to your work, you've got the settlement on the table, that seems to be great, and the personal injury attorney says, look, this is a great settlement, and the client's, says, no, I want a lot more. Well, what happens when you file the bankruptcy? The trustee will step in, and the trustee will have to review the case. He doesn't take complete control, but he works with the personal injury attorney. He makes the evaluation, and he can say, look, this is a great settlement, and it's kind of like a third party review of everything, and can recommend and can enforce a good settlement, even if somebody's unreasonable. So if a personal injury attorney is like dealing with somebody who's just isn't being rational with the value of their case, it is a good option for them to really put them in the bankruptcy, get rid of their debt. They're often going to get a discount. And then they're also going to get some exemptions. So what's exemptions, let me explain real quick, is that not all your money's taken to your creditors. Even if you got a settlement and you put it in your bank account and you didn't file bankruptcy, that could be taken as a garnishment. They could come and garnish the bank account really quickly. You still are going to get sued, and you can't be transferring it to different places. So you have to deal with both. So the trustee is a very solid option to make sure rationale, calm comes back to the situation. Because sometimes, too, a trustee will issue, if he thinks there's assets potentially, he'll issue a request for what they call proof of claims. The creditors just say, we owe something. And a lot of times creditors will not file those. It's a pretty much a 50-50 shot sometimes. Therefore, you get a discount, even without doing anything. You just get a discount. So that's an option too.
Now you just said something that I find interesting, because I've heard a few bankruptcy attorneys, a few PI attorneys tell me otherwise. But you say, well, the trustee comes in and helps make these rational decisions. I have a feeling there may be a few trustees maybe who aren't making such rational decisions, and they do get paid a portion of what they liquidate. So what happens in a situation where the trustee says, oh, wait a minute, you got $50,000 settlement on the table, I want you accepting that. Do you, as does the debtor have the opportunity to fight that, or do they just have to roll over and whatever the trustee says goes?
Well, your personal injury attorney is supposed to be the expert. Trustees are not experts on personal injury. Oftentimes, a trustee will get an advisor and work with the personal injury attorney. I mean, everything is based on, experience and what his standard and reasonable. And if it's not reasonable, the trustee says, take $5,000 and the case is worth $50,000. Your personal injury attorney has the right to object to that and say that's not reasonable. And honestly, the judge is going to listen to the person who does personal injury every day versus a trustee who just happens to have a case. However, the trustee a good trustee, that is, will have an advisor or will hire an attorney who does personal injury. And that personal injury attorney will know and should know and be on the same page as your personal injury attorney as what is reasonable and what is not.
Well, that makes sense. Now, one thing I imagine that a lot of PI attorneys or comp attorneys or anybody might be a little concerned about is, because you're now going into another court, the federal court, what happens to their legal fees? Is there any chance that they're not going to get paid their third or anything to that extent?
That's one of the biggest fears of personal injury attorneys. They're like, well, it's like, it's like my kid in her bedroom. She doesn't want anybody in there. Oh my God, you're messing with my stuff. Don't touch it. It's mine. I don't want you to do it. I'm like, I'm just cleaning your floor so you can actually walk on it without sticking to it. But no, right? That's the kind of thing it goes. Yeah. So the attorney's entitled to what his contract said, whatever his retainer is, whatever it's, third and a half, there isn't any issues. They'll be approved. You might have to file a motion and get those approved, and there won't be an issue with that, because unless you're asking, like, unless my kid is hiding chocolates under the couch or something, right, in her playroom, and she's not supposed to have those there. So as long as you're not doing something illegal or outside the realm of standard reasonableness, you'll get your fees. I mean, if you're going to ask for 50% on your personal injury issue, you've got a lot more problems than the trustee and the bankruptcy court. So
this is true. And now you did keep saying, oh, well, the personal injury attorney might have to file a motion, or the judge can ask the personal injury attorney what they think about the case. And just to make sure that we're kind of on the same page here, you're not suggesting that, when someone refers a case to a bankruptcy attorney like yourself, that you make the other attorney go in and file all the motions. That's still something that the bankruptcy attorney does. The other attorney is more of just a witness, correct?
yeah, and yeah, the bankruptcy attorney would work with that and do that. And it depends on your relationship, and it also depends on the trustee. The trustee might do it. He might just do it. His trustee attorney might say, okay, we settled it. My attorney's filing the motions. It all depends on the trustee and the jurisdiction you're in and what the standard procedure is. And those are up in the air. And oftentimes, like, I know I will file them for the personal injury attorney, because that's just what we do. We help them out. We can take care of that. But I've had trustees in our jurisdiction also just file them, and on behalf of everybody involved, because they're just doing it anyhow, so they just get it done. So those are options, but don't worry, personal injury attorneys, your fee is safe, as well as, if anything, it's probably in better situation, because now you have a third party, a trustee, with telling your client, helping, especially if it's a difficult client, helping them understand the process. And when they walk out of that bankruptcy case, not only do they have the settlement, you have your fee, but now you're not going to get those phone calls. I need more money. I should have been paying on these. My settlement didn't cover enough. Why didn't you get me more money to cover my credit? That won't be the case, because the whole bankruptcy will resolve everything for everyone.
That's really good to hear. So, I mean, what I'm hearing really is that even if your primary concern is a divorce, is a injury, a workplace injury, a slip and fall, whatever it might be, that the overriding debt that creates all this stress, there's always going to be options for them. And there's always opportunities, I think, to network, and all our listeners, I know you're in different areas. We have criminal lawyers, we have bankruptcy lawyers, we have PI guys, we have comp guys, we have some immigration lawyers. There's always that opportunity to kind of, meet together and to have, a joint task force, as it was, to help out the client. And at the end of the day, I think the clients are the one who wins really more than anybody in any of this.
Absolutely. And I say, call me, because we might be able to alleviate the debt issue. Like, we're not complicated in the sense that we have a lot of things, but it's, if you can alleviate some debt between parties, maybe it's an easier divorce for both parties. If it's easier with regards to a personal injury case where someone really is worried about, people have anxiety and debt stresses people out, and it's about health too. If you can resolve some of this debt issue, and the best part about the bankruptcy part, the 7s or the 13s, is that you can reset your debt. You have an opportunity to clear that out, and people can move forward. And it's amazing how much the pressure from the client will happen, and it will also happen from the attorney, because if there's not a lot of pressure, the client is going to be easier to work with and resolve other issues.
That makes sense. Well, you've dropped some real gold nuggets of information on us today here, Jill, and I want to thank you for that. But let me ask you this, for any of those people out there who are listening and want to get a hold of you, what's the best way for them to get in touch?
So you can email me at jp@Phillips, PHILLIPS, law, LAW, East, EAST.com. So that's jp@PhillipsLawEast.com. Or feel free to give us a call at the office at 301-494-4250.
Thank you so much for your time today. Thanks for all the information. I mean, this is really helpful, very informational. Definitely, we need to do this again, maybe in 6 months, because I know the laws certainly do get updated from time to time, and just kind of helping people find, the right connections within the legal net, within their legal network.
Very good.
All right. Well, thanks so much. Again, this was Mike Goldstein with the Best Known Attorney Podcast, and we will speak to you again soon. All right. Bye-bye.
Thank you.